Students. Today is Wednesday, 6 April 2022. Today we'll begin our second lecture on the case of Atkins versus Virginia. I have a few items posted on Canvas. Let me run through them quickly. First of all, I have posted the case itself, Atkins versus Virginia, 2002. I have also posted a handout entitled Eighth Amendment Cases, which we went over a couple of days ago. I then posted my lecture notes on this case, so you can print them and put them in front of you as you watch the video, follow along. I found an interesting video on YouTube that contains an interview with Martin Luther King Jr. It's an interview I had never seen before, and I found it fascinating. So I thought I would post it on Canvas for you to watch. Now, we've already gone over King's letter and you've been tested on it, but I posted that video for your own information. I hope you watch it. The next item I posted is a map. It's a map that shows what the various states have done with regard to the death penalty. And the map is as of 2021, but I don't think anything's changed in the past year. And you can see that the country is about roughly split on states which allow capital punishment, such as Texas, and states which prohibit it. The Supreme Court has never ruled that the Eighth Amendment prohibits the imposition of capital punishment. Maybe one day it will rule that way. There are justices on the Supreme Court who hold that view, but they've never been in a majority. I have a couple more handouts to post on Canvas. Later today, I will post a picture of the justices who were on the court when this case was decided. And then I have a couple more items in the next few days. Okay, another item, the third and final exam for the semester will be on Tuesday, 10 May, the 10th of May. That's the date that's listed on the syllabus. It's listed on the reading list. It's been the date of our third exam all along. The reason we'll be taking the exam that day is because the university assigns to each class a particular time for the final exam, and we'll be making use of the first 80 minutes of that time period. So the exam will be from 8 o'clock in the morning until 9:20. 1 hour and 20 minutes, the same amount of time you've had for the other two exams. So get that on your calendar, Tuesday, 10 May. It's a little over a month away, so don't start worrying about it yet. But make sure you do your work. Make sure you keep up on the reading. Make sure you watch the videos as they're posted. Don't put off the viewing of the videos until the final couple of days. There simply won't be enough time for you to watch all of them. Okay, so today, lecture 2 out of 3 on the Atkins case. Now you may recall, in this case there is a majority opinion. There are 2 dissenting opinions. The first dissenting opinion is by Chief Justice William Rehnquist, and the second dissenting opinion is by Justice Antonin Scalia. So the 3 opinions were written by Stevens, Rehnquist, and Scalia. We're almost done discussing Stevens' majority opinion. We have a little bit left to go. And the rest of today we'll devote to Chief Justice Rehnquist's dissenting opinion. And that means that on the third day, which is next Monday, we'll discuss the dissenting opinion by Antonin Scalia. So let's get back to the majority opinion. Justice Stevens, writing for the other 5 members of the majority, says that the court must find evidence of prevailing standards, or what the court called contemporary values. What is the consensus in the country about whether executing or putting to death mentally retarded individuals is compatible with the Eighth Amendment, whether it's cruel and unusual punishment. And according to the majority, the thing to look at is the state legislatures. What have the 50 state legislatures done on this question? Do they allow the execution of mentally retarded individuals, or do they not? On pages 315 and 316 of the opinion, Justice Stevens writes the following: the large number of states prohibiting the execution of mentally retarded persons and the complete absence of states passing legislation reinstating the power to conduct such executions provides powerful evidence that today our society views mentally retarded offenders as categorically less culpable than the average criminal, unquote. So the first thing Justice Stevens does, he and his fellow members of the majority, is look at what the state legislatures have done. And he finds that the movement has been all in one direction. States that previously allowed the execution of the mentally retarded have changed their laws to disallow it. No state that previously disallowed it has changed its law to allow it. So the movement is completely in one direction only, and that's toward abolishing the death sentence for the mentally retarded. Justice Stevens concludes on page 316, the practice, therefore, has become truly unusual, and it is fair to say that a national consensus has developed against it. Now, the inquiry is not yet completed because it's a two-part test. First, look at what the state legislatures have done. And secondly, once you determine that, the court has to make its own independent judgment. The court can decide to overlook the evidence of the legislatures, or it can decide to affirm it, to uphold it. In this case, the court voted to uphold it. And it has two reasons for doing so. There are two reasons, according to the majority, why, quote, the mentally retarded should be categorically excluded from execution, unquote. In other words, there are two reasons why the court should interpret the Eighth Amendment as ruling out categorically, meaning the whole category of the mentally retarded from being executed. And the first reason is that the purposes of punishment would not be served by executing the mentally retarded. Let me begin with a quotation from pages 318 and 319. Justice Stevens writes, quote, there is a serious question as to whether either justification that we have recognized as a basis for the death penalty applies to mentally retarded offenders, unquote. Now, what are those two justifications that the court has used in the past for the death penalty? They are retribution, which, as you know by now, is punishment for the sake of punishment. Retribution means paying people back, giving them what they deserve, even if no good comes from it, in the form of deterrence. That's called retribution. And secondly, deterrence. One of the longest standing and oldest justifications for punishment is deterrence. The idea is that if we punish one person, we can deter others from committing crimes. And everybody benefits from that. So deterrence is forward-looking. It looks into the future to see what good would come from punishing. Retribution is backward-looking. Retribution looks back to see whether a crime was committed and what it deserves in the way of punishment. So let's apply these two justifications to the case of executing the mentally retarded. Justice Stevens says, first of all, they don't deserve to die. The mentally retarded are not as culpable as those who are not mentally retarded. Presumably, or by implication, he's suggesting that those who are not mentally retarded deserve to be put to death. But those who are mentally retarded do not. So retribution would not be served if the mentally retarded were put to death for their murders. The second point that Justice Stevens makes is that deterrence would not be brought about by punishing, by executing the mentally retarded. Deterrence works only if people are rational. We've talked about this already when we talked about Stephen Wise's essay on animals. Animals are not moral agents. You can't deter an animal from doing harm because they can't reason. Deterrence works like this. You punish one person and then you publicize it. And you hope that other people will reason as follows. So-and-so was just punished for committing a particular crime. I don't want to be punished like that. Therefore, I will take pains not to commit that crime. Notice there's a reasoning process involved. Justice Stevens seems to be saying that mentally retarded individuals, because of their mental retardation, cannot engage in that reasoning process. And if that's true, then they're not deterrable. They're not capable of being deterred. So the deterrence rationale for punishment doesn't apply in this case. It applies only to people who are capable of reasoning, and that's supposedly not true for the mentally retarded. Now you'll notice I have the word query in my notes, as I do several times. These are questions that came to me as I was reading the opinion, and I would like to ask Justice Stevens, if I could, this question. Are you saying that the mentally retarded are culpable or blameworthy enough to deserve life imprisonment without parole, but not culpable or blameworthy enough to deserve to be put to death? Once again, we're back to the threading the needle problem. Justice Stevens seems to want it both ways. The mentally retarded are responsible enough to be put on trial for crimes, to be convicted of committing those crimes, to be sentenced to a term of punishment for those crimes, but not for a particular punishment, namely death. And I have a lot of questions about that. What exactly, how can somebody be culpable enough to spend his or her entire life in prison with no possibility of parole, but not culpable enough to be put to death? I don't have an answer to that question, and it does need to be answered. What I'm suggesting is that the argument being made by the majority goes too far. It's an argument against punishing the mentally retarded at all. And yet they think it's an argument against a particular type of punishment, namely capital punishment. So that's one way you criticize an argument. You try to show that it goes too far. It encompasses too much. And that's what I'm saying. One final point before we get to the dissenting opinions. On page 321, Justice Stevens writes the following: mentally retarded defendants in the aggregate face a special risk of wrongful execution, unquote. Now that's interesting. It's a separate point that he has not made it yet. He's saying this, I think, in a particular trial, whoever is being tried has attorneys or counsel to represent them in court. But they are present in court, and they can and should assist their attorneys, their counsel. Not only in court during the trial, they can talk to one another, but they can talk outside of court, right? The defendant always is in close contact with the attorneys. Justice Stevens seems to be saying here that because of the mental retardation, these individuals are not capable of rendering assistance to their attorneys. And if that's the case, then maybe it's unfair to hold them responsible for their crimes. Maybe it's unfair to put them on trial at all. Another possibility is that because of the mental retardation, a particular defendant may make a false confession. This may sound crazy to you, but it's a fairly common occurrence. It's a well-known phenomenon. People end up confessing to things that they didn't do, sometimes to things that they know they didn't do. And I won't go into some of the details as to why they would do such a thing, but it's a common phenomenon. It's probably more likely that a mentally retarded individual will make a false confession than someone who's not mentally retarded. In other words, there's a special risk, notice those are Stevens' words, a special risk of wrongful execution that accompanies the mental retardation. So they not only are unable to give meaningful assistance to their attorney or counsel, but they may, when they're discussing, when they're conversing with police officers shortly or even before they're arrested, they may say things that end up being treated as confessions to the crime. So Justice Stevens is worried about this. It's an additional problem that makes him reluctant to allow the death penalty for the mentally retarded. They may be wrongly convicted, and that would be a grave injustice if someone who is not guilty ends up being convicted and sentenced. Okay, so I think that's enough. That completes our discussion of the majority opinion. Let's turn now to the first of two dissenting opinions. The first one is by Chief Justice William Rehnquist. Oh, by the way, before we get to Rehnquist's dissenting opinion, I noticed I have a note at the bottom of my page 3, and it says, read the marked paragraphs on page 321. So would you turn to that page and we'll take a look at the final or penultimate paragraph of Justice Stevens' opinion. Here's what he says. Our independent evaluation of the issue reveals no reason to disagree with the judgment of the legislatures that have recently addressed the matter and concluded that death is not a suitable punishment for a mentally retarded criminal. We are not persuaded that the execution of mentally retarded criminals will measurably advance the deterrent or the retributive purpose of the death penalty. Construing and applying the Eighth Amendment in the light of our evolving standards of decency, we therefore conclude that such punishment is excessive and that the Constitution places a substantive restriction on the state's power to take the life of a mentally retarded offender. Okay? And that's the Eighth Amendment together with the 14th Amendment, which makes the Eighth Amendment applicable to the states like Virginia. Well, we may as well read the final short paragraph because that always tells you what the court's conclusion is, what the court is going to do with the case. The judgment of the Virginia Supreme Court is reversed. Now, what was the judgment? The judgment of the Virginia Supreme Court was to affirm the sentence, the conviction and sentence of death. The Supreme Court of the United States is reversing it. And the Supreme Court is also remanding the case, which means literally hand back. Re means back, and mand is the root of the word hand, M-A-I-N, hand back or give back. So the court says to the Supreme Court of Virginia, you made a mistake. We have corrected your mistake. We're going to give the case back to you for further proceedings not inconsistent with this opinion. So the Virginia Supreme Court will have to take the case again and dispose of it. The court may have to order a new trial to see what punishment may be administered to Atkins, given that he cannot be put to death. Okay, so that's the majority opinion. Let's turn now to Chief Justice Rehnquist's dissenting opinion. Now I have just a little over 1 page of notes on this, so we'll see how it goes. Maybe we'll be done within an hour. And if so, that would make up for a couple of days where I went longer than an hour and 20 minutes. Okay, Chief Justice William Rehnquist wrote the following dissenting opinion, and he wrote on behalf not only of himself, but 2 other justices who dissented, Scalia and Clarence Thomas. Scalia ended up writing his own dissenting opinion. So he not only signed on and agreed with everything we're about to discuss in Justice Rehnquist's dissenting opinion, but he decided he would write separately to make some further points. Justice Thomas didn't write a word. He often does write a dissenting opinion, maybe more than anyone else, but in this case he chose not to. He must have liked Chief Justice Rehnquist's opinion and the opinion by Scalia because he joined both of them. He in effect said, I agree with everything my fellow Justice Rehnquist has written, so I'll sign on to it. And I agree with everything my fellow Justice Scalia has written. I'm going to sign on to it as well. But he didn't have anything extra to say. Okay, let's get started. You may be surprised to learn that Chief Justice Rehnquist agreed with the standard that Justice Stevens used. It's called the Evolving Standards of Decency standard or test. Justice Rehnquist said, that's the appropriate test that we must apply to this case. So where did he disagree? He disagreed with the majority about what constitutes evidence for these evolving standards of decency. What would be evidence for contemporary values in society? And Chief Justice Rehnquist thinks that the court used inappropriate things as evidence, 3 of them in particular. He says the court used foreign laws or international opinion, and he's going to go on to point out that's irrelevant. That is not evidence at all on the question of what the national consensus is in the United States. Secondly, he says that the majority made use of, quote, the views of professional and religious organizations. Again, Justice Rehnquist says that's irrelevant. That is not evidence, at least that's not appropriate evidence of contemporary values on the question of putting to death retarded individuals. And third, Justice Rehnquist takes issue with the use of opinion polls, which the majority did. So why don't we begin with the majority opinion, footnote 21. In case you're wondering, where did the majority make use of these types of evidence? It was in footnote 21. So let me go to my copy of the opinion, which is in my notebook, and I'm going to find footnote 21. I'll tell you the page in a moment. Getting close. Footnote 21 begins on page 316 of the official reported Supreme Court case. Page 316, footnote 21. Now, this is the majority, Justice Stevens writing. Here's what he says. Additional evidence makes it clear that this legislative judgment reflects a much broader social and professional consensus. For example, several organizations with germane expertise have adopted official positions opposing the imposition of the death penalty upon a mentally retarded offender. and he cites the brief filed by the American Psychological Association, a brief filed by the American Association on mental retardation, and he goes on to say the following. In addition, representatives of widely diverse religious communities in the United States, reflecting Christian, Jewish, Muslim, and Buddhist traditions, have filed an amicus curiae brief, which means friend of the court brief, explaining that even though their views about the death penalty differ, they all share a conviction that the execution of persons with mental retardation cannot be morally justified. Okay? Moreover, I'll turn the page. Moreover, within the world community, the imposition of the death penalty for crimes committed by mentally retarded offenders is overwhelmingly disapproved. And here, the majority cites a brief filed by the European Union. Finally, polling data shows a widespread consensus among Americans, even those who support the death penalty per se, that executing the mentally retarded is wrong. And they cite a New York Times article in support of this. Also, there was an appendix in the brief filed by the American Association on Mental Retardation showing poll data. Although these factors are by no means dispositive, in other words, they don't alone dispose of the issue, their consistency with the legislative evidence lends further support to our conclusion that there is a consensus among those who have addressed the issue. So Justice Stevens quite clearly is saying here that there's lots of evidence in support of the proposition that there is a national consensus against putting to death those who are, or who were at the time of their crimes, mentally retarded. Okay? So I wanted to actually read that footnote to you. It's a little bit long to show you that Justice Rehnquist isn't just making this up. The majority really did use as evidence these items, and he's going to go through one at a time and show why they're irrelevant. They should not have been taken into account by the court at all. And in future cases, they shouldn't be taken into account either. Why? Because they're, strictly speaking, irrelevant. They have nothing to do with the issue. The issue is about a national consensus. And these items that were cited in the footnote are irrelevant to that. Now, he may be wrong about that. I'm stating his opinion, his view. Okay, let's look at his own statement of the issue. It's in my lecture notes on page 4. It's on page 321. The question presented by this case, the issue, is whether a national consensus deprives Virginia, or any other state, of the constitutional power to impose the death penalty on capital murder defendants like petitioner, that would be Atkins. That is, those defendants who indisputably are competent to stand trial, aware of the punishment they are about to suffer and why, and whose mental retardation has been found insufficiently compelling reason to lessen their individual responsibility for the crime. Remember, Atkins was found guilty by a duly impaneled jury in a court of law, and the highest court in the state of Virginia affirmed or upheld his conviction and his sentence. They had no problem with his mental retardation being a barrier to imposition of the death sentence. Now, Rehnquist's answer to that question is no. There's no national consensus that deprives Virginia or any other state of the power to impose the death penalty on the mentally retarded. I should tell you as you can see in my notes, Rehnquist was a notorious Federalist. He's not the only one, of course, but in a great many cases, Chief Justice Rehnquist said that states should be able to decide these matters for themselves without the intrusion of the federal government. So Rehnquist often took a hands-off approach. He said that states should be able to do as they please in a particular area without the court supervising them. Only if there's a clear constitutional prohibition on the states being able to do something should the court strike it down. So what Rehnquist's general view is that states are sovereign on a great many issues, and only when the U.S. Constitution clearly takes the power away from them should the court strike down what they're doing or rule that what they're doing violates the Constitution. That's called federalism. It's a point of view that gives the states authority to make certain decisions on their own without being overruled by the court. So why did Justice Rehnquist dissent? He says the following on page 322. He says, I write separately to call attention to the defects in the court's decision to place weight on foreign laws, the views of professional and religious organizations, and opinion polls in reaching its conclusion. The court should not have used those items at all, as it clearly did in that footnote. So let's take these, in a moment we'll take these one at a time and see what Justice Rehnquist says about them. What are the appropriate sources of evidence according to Chief Justice Rehnquist? He says on page 324, in my view, two sources ought to be the sole indicators by which courts ascertain the contemporary American conceptions of decency for purposes of the Eighth Amendment. Two sources ought to be the sole indicators. What are these two sources? You'll notice when I quoted him, I skipped over them. The work product of legislatures and sentencing jury determinations. Those are the only things the court should look at. What are the laws on the books of the 50 states regarding execution of the mentally retarded? And what are juries actually doing? Look around the country at cases where mentally retarded individuals have been tried for capital murder and see what the juries have done. Have the juries sentenced them, found them guilty, and sentenced them to death? Or have they not sentenced them to death? That's a relevant piece of evidence for prevailing standards. If juries are doing it routinely around the country, that's good evidence that putting the retarded to death for capital murder is not a violation of prevailing standards. So let's take up the three items that Chief Justice Rehnquist thinks are irrelevant, that should not have come into play at all. We'll begin with foreign laws or international opinion. Chief Justice Rehnquist says on page 325, if it is evidence of a national consensus for which we are looking, then the viewpoints of other countries simply are not relevant, unquote. Now, what does relevant mean? Something is relevant to something else when it has any tendency to support it or to make it true. So what if the question was what day it is today? It's a silly example, but what if two people were in doubt about what day it is? For some reason, they had a disagreement about that. What would be evidence for or against it being Monday or Wednesday? Let's say Wednesday, which is today. Well, what if one of them said, to support the proposition that it's Wednesday, I had a hot dog for dinner last night? That's irrelevant. That has no tendency whatsoever to verify or falsify the proposition that it's Wednesday. It's irrelevant. Justice Rehnquist seems to think that evidence of what foreign laws exist or what international opinion says has nothing to do with the national, whether there's a national consensus on putting to death the mentally retarded. We shouldn't look at foreign law or international opinion at all. And since the majority did so, they made a mistake, according to the Chief Justice. So what he's saying is, in future cases, we shouldn't bring these matters into play at all. He's criticizing the majority, his fellow justices, for using what he considers irrelevant evidence. Now, I'm sure the majority doesn't consider it irrelevant. They might well disagree with the Chief Justice that it's irrelevant. And that debate would have to be carried on at another level. They would have to then argue about why it is or is not relevant. But I want you to realize that the Chief Justice thinks it's irrelevant, meaning it has no bearing on the question before the court. Okay, the next item that Chief Justice Rehnquist talks about is the views of professional and religious organizations. You saw that those were cited in the footnote that we read. Here's what he says on page 326. In my view, none should be accorded any weight. I think what he's saying is no views of religious or professional organizations should be accorded any weight on the Eighth Amendment scale when the elected representatives of a state's populace have not deemed them persuasive enough to prompt legislative action, unquote. Now, what is he saying? Suppose you've got a state like Virginia, which allows the execution of the mentally retarded. The legislature of the state of Virginia has every right to look at the views of professional organizations like the American Psychological Association and of various religious organizations. And the legislature of Virginia could, having taken those views into account, amend its laws, either to rule out execution of the mentally retarded or to allow it only in certain narrow cases, or perhaps to allow it in all cases of mental retardation. But the state of Virginia has not done that, Chief Justice Rehnquist is saying. The only relevance of these professional and religious organizations' views, the only relevance is they should take it to the state legislatures around the country. They shouldn't come to the Supreme Court and file a brief. They should lobby state legislatures in Virginia and in other states to try to get those state legislatures to change their laws so that they no longer allow execution of the mentally retarded. Now, I have a note to read the marked paragraph on page 326. So let's do that. Go to page 326 of the dissenting opinion. There I am. I found it. And it's quite short. I just want to read a little bit of one of the paragraphs. Here's Chief Justice Rehnquist speaking. For the court to rely on such data today serves only to illustrate its willingness to proscribe by judicial fiat at the behest of private organizations speaking only for themselves, a punishment about which no across-the-board consensus has developed through the workings of normal democratic processes in the laboratories of the states. Judicial fiat. Now that should hurt. When the majority reads that, it should pain them. Chief Justice Rehnquist is saying that the court is proscribing the use of capital punishment for the retarded by just decreeing it, right? Judicial fiat. They are acting at the behest of various private organizations and religions. They are using that as evidence of a national consensus. But the best evidence is what the state legislatures have done through the democratic process. Remember, the process works like this. The voters of the states go to the polls on election day. They vote for their representatives at every level of government, at the local level, at the state level, and at the federal level. Those individuals then make laws that supposedly reflect the will of the people. And those laws then are on the books and they are to be followed. Justice Rehnquist says that if we care about democracy, we should look at the actual laws that the states have. And about half the states allowed execution of the mentally retarded. Virginia did. And the court, by judicial fiat, saw fit to strike down all of those democratically written laws in states like Virginia. And they did it at the behest of private organizations like the American Psychological Association and various religions, which are not arms of the government, of course. So Chief Justice Rehnquist thinks that the majority is pulling a fast one. They're acting in a very undemocratic way in striking down these laws all over the country. Okay, the third and final piece of evidence that the majority made use of that Chief Justice Rehnquist thinks is irrelevant is opinion polls. Here's what he says on page 322. He says, we lack sufficient information to conclude that the surveys were conducted in accordance with generally accepted scientific principles or are capable of supporting valid empirical inferences about the issue before us. The court wasn't presented any evidence of the reliability of these polls or surveys. Did they or did they not conform to generally accepted scientific principles? We don't know, he says. We don't know because we were not allowed to cross-examine anybody. In fact, the Supreme Court has no power to cross-examine anyone under oath. That should have been done at the trial. If these polls and surveys had been introduced at the trial of Daryl Atkins, then the prosecution could have put on the witness stand under oath the pollsters and asked them tough questions about how the polls were conducted and were they conducted in accordance with generally accepted scientific principles. But that didn't happen, apparently. And the court is saying, we don't know what to make of these polls and surveys. Are they reliable? Who knows? We can't decide that. So we shouldn't make any use of them. You don't make use of unreliable evidence. He also says on page 326, quote, an extensive body of social science literature describes how methodological and other errors can affect the reliability and validity of estimates about the opinions and attitudes of a population derived from various sampling techniques. In other words, we know for a fact that many of these polls and surveys are unreliable. We don't know whether these particular surveys are unreliable, but we know in general that polls and surveys are unreliable to a certain extent. So why should we make use of these particular polls and surveys when it has not been demonstrated that they're among the reliable ones? Bear with me for a second. I want to look at page 326 to see whether Chief Justice Rehnquist cited any support or any studies for that proposition. He says, where is it? It's at the bottom of page 326, and he does indeed cite a scientific study. He says, see, for example, R. Grove's Survey Errors and Survey Costs. That's a book published in 1989, and he also cited a second book, Turner and Martin. The book is entitled Surveying Subjective Phenomena. So Chief Justice Rehnquist is supporting his claim that these surveys and polls are, to some extent, unreliable. He cited two books in support of that claim. He didn't just make it up. If he did, he would be doing exactly what he criticizes the majority of doing, which is making unsupported claims. And finally, on pages 327 and 328, the Chief Justice writes, in order to be credited here, such surveys should be offered as evidence at trial, where their sponsors can be examined and cross-examined about these matters, unquote. Have you ever heard the saying that cross-examination is the best engine for truth discovery ever invented? In a trial where every witness is put under oath to tell the truth, the whole truth, and nothing but the truth, in a trial, each witness is both examined by one side and cross-examined by the other side, by the attorneys. And that process of examination and cross-examination is supposed to elicit the truth. The truth is said to be more likely to emerge from that process than from any other process we can imagine. There's no guarantee that the truth will emerge, but that's the best process ever invented for increasing the likelihood that the truth will emerge. And the truth, of course, is our goal in a trial. We want to get the truth about what actually happened. Did Atkins fire the gun? Someone may have said he didn't fire the gun. Someone else says, yes, he did. That's a factual dispute. And the only way to find out who fired the gun on that occasion is to put various people on the stand and both examine and cross-examine them. The jury, observing their testimony and their demeanor, will have to decide in the end what the facts are. The jury will decide who in fact fired the gun, Atkins or someone else. By the way, the appendix, and we'll take a look at it in a moment, Chief Justice Rehnquist appended a number of survey and poll results to his opinion. And these poll and survey results, he says, were reported by the American Association on Mental Retardation. Now, I put a footnote in. I found it interesting that the organization just 20 years ago was called the American Association on Mental Retardation. And I looked it up because I thought to myself, that name may well have changed in the past 20 years. And sure enough, it has changed. So let's read the footnote on page 5 of my notes. Founded in 1876, AAMR, which is the American Association on Mental Retardation, is the oldest and largest interdisciplinary organization of professionals and others concerned about mental retardation and related disabilities. The first meeting of the, quote, Association of Medical Officers of American Institutions for Idiotic and Feeble-Minded Persons, unquote, was held at the Elwyn Training School in Elwyn, Pennsylvania. So that was the original name of the organization. It's shocking by our contemporary standards, isn't it? It's, what is it called? Association of Medical Officers for Idiotic and Feeble-Minded Persons. Okay, the organization later changed its name to American Association on Mental Deficiency. Okay, the idea must have been that that's less pejorative, right? It's less demeaning. In June 2006, members of the association voted to change the name of AAMR to the American Association on Intellectual and Developmental Disabilities. So there have been 4 names in this organization's history, and it's apparently currently known as American Association on Intellectual and Developmental Disabilities. Okay, so I've been calling it the AAMR because that's what it was called when this case was handed down. Okay, the final thing I want to do for today is I want to look at that list of surveys and polls that Chief Justice Rehnquist appended to his dissenting opinion. It begins on page 328 and it goes all the way to page 337, which means for 10 pages of this opinion, there's nothing but a list of polls and surveys. And he put them in by state in alphabetical order. He says, appendix to opinion of Rehnquist, CJ, Chief Justice, and then it says poll and survey results reported in the brief for the AAMR, which was a friend of the court brief filed with the court. So take a look at the first poll. It's from the state of Arkansas. The poll is entitled Arkansans or Arkansans. I've heard it pronounced Arkansans. Arkansans' opinion on the death penalty. It's from the Opinion Research Associates, Incorporated. Question 13, July 1992. The question goes like this. Some people say that there's nothing wrong with executing a person who is mentally retarded. Others say that the death penalty should never be imposed on a person who is mentally retarded. Which of these positions comes closest to your own? And here were the responses. 61% said never appropriate. 17% said is appropriate. 5% said opposed to all executions, not just those involving the mentally retarded. And 17% said undecided. Now here's what's interesting. That question has to do with, it says, executing a person who is mentally retarded. But in the case of Atkins, the question was what to do with individuals who were mentally retarded at the time they committed the crime. Not necessarily at the time of punishment. So the poll question, the survey question, strictly speaking, doesn't apply to this case. It should say, some people say that there's nothing wrong with executing a person who was, at the time of the commission of the crime, mentally retarded. That would focus in on the appropriate time period. And I think that alone shows you some of the problems with these polls and surveys. They're not fine-grained enough. Some of them are ambiguous. Some of them are vague and open-ended. Okay, page 2, you'll see that there's at least one poll from Arizona, California, another California poll, Connecticut, and so on. Let's just skip through. Maybe we'll take a look at one more to give you an idea. Here's one from Texas. In the year 2001. It's a poll or survey conducted by Scripps Howard on the death penalty. And here was the question asked: should the state use the death penalty when the inmate is considered mentally retarded? And 66% of the respondents said no. Okay? Here's a question from another poll in Texas conducted by the Houston Chronicle, or at least paid for by the Houston Chronicle. Would you support the death penalty if you were convinced the defendant were guilty, but the defendant is mentally impaired? Well, mentally impaired may have a different meaning than mentally retarded. So how useful is a poll when the terms aren't even the same? Okay. Next page, 335. Do you favor or oppose the death penalty for mentally retarded individuals convicted of serious crimes such as murder? And so on and on. You can take a look at some of the questions yourself. Why did Chief Justice Rehnquist put this in his opinion? It took up 10 pages. Taxpayers had to pay for that because the U.S. reports is paid for and published at taxpayer expense. He must have thought that it's an important part of his argument. I think the point he's making, and I may be wrong, but I think he's saying, look at some of these poll and survey questions. Look how haphazard they are. Look at how different they are. Look at the difference in the response rates and in the respondents who answered one way rather than another. I think he's trying to show that these polls and surveys are unreliable, and therefore the court should not make any use of them. The best evidence, in his view, for contemporary values or prevailing standards is what state legislatures have actually done, what's on their books, and someone needs to do a study of what juries have done. Take a look at all the cases over the past, say, 10 years, every case in which someone who was mentally retarded at the time of commission of the crime was tried for capital murder, and see how many convictions there were, and see how often the jury sentenced these individuals to death as opposed to life imprisonment. That would be relevant evidence, what the juries have actually done and what the legislatures have actually done. But we should not be looking at foreign governments or international opinion. We shouldn't be looking at private organizations such as the American Psychological Association. We shouldn't be looking at religious organizations. They have their own views on capital punishment, and that's to be respected. But we're judges, and we're trying to determine what the Constitution means. And we're trying to apply that to this case involving the mentally retarded. And for that purpose, we shouldn't be looking at religion at all. I mean, should we be looking at religious views when it comes to other issues like abortion and euthanasia, the right to die, the right to life, things like that? And I think the answer is no. These are judges, and they're interpreting and applying the Constitution. And for that purpose, we shouldn't ignore what religions have to say about these issues. Okay, that takes us up to almost 1 hour. I thought it would be a little bit shorter. We have one more opinion to discuss, and we'll be done with this case. Make sure you've read the dissenting opinion by Chief Justice Scalia carefully before you watch my video next week. I'm going to continue posting these videos every Monday and Wednesday for the rest of the semester. And if anybody comes to class, and nobody has been coming for quite a while now, if you come to class, I will be there. I'll let you ask questions. Any questions you have, that's the time to ask them. And it may lead to a discussion. But I'm not going to do the lecture all over again, since I'm doing that online. Right now, I'm doing the lecture. So you can stay home and watch the lectures if you want. If you do come to class, make sure you have some questions to ask. All right, have a great day and a great weekend. The baseball season begins tomorrow. Maybe you don't care about that. Some of you may. I'm quite excited about it. I love baseball. So I'm looking forward to that, and I'll probably watch a few games this weekend. Okay, have a great day again, and I'll see you on the screen next week.